All right, let's dive right into this massive 2024 Supreme Court of India judgment to understand the complex, on-the-ground realities of immigration law. Today, we're entirely stripping away the intense politics that usually surround this topic, and we're going to focus purely on the facts, the constitutional issues, and the final ruling. It's honestly an incredible case study in how the highest court in the land balances history, demographics, and the law.
To make sense of this highly debated topic efficiently, here is our roadmap for today's explainer. First, the facts on Section 6A. Second, the preliminary issue of delay. Third, the constitutional issues. Fourth, the majority ruling. And finally, the dissenting opinion.
Section 1. The facts. Section 6A.
So this 2024 judgment revolves around Section 6A, which is a special, sui generis, meaning entirely unique, provision added to the Citizenship Act back in 1985. It was enacted specifically to give statutory effect to the Assam Accord. Now, for some quick context, this accord was a major political settlement reached after years of intense and sometimes violent protests over the massive influx of undocumented immigrants into Assam from Bangladesh. The law was essentially a compromise, a way to legally settle a deeply volatile situation on the ground.
And the core mechanics of Section 6A actually rely on very distinct cutoff dates to categorize migrants into three specific groups. It's kind of like a three-tiered system. If you came to Assam before January 1, 1966, you were deemed a regular Indian citizen. Simple enough. If you came between 1966 and March 24, 1971, you had to register and wait 10 years before getting full voting rights. But anyone who crossed the border on or after March 25, 1971 was to be detected and deported as an illegal foreigner.
Moving on to Section 2, the preliminary issue, delay.
Okay, before we even get to the Constitution, we've got to talk about a really fascinating legal hurdle known as the doctrine of laches. The respondents in this case pointed out that Section 6A was passed in 1985, yet the writ petitions challenging it were filed in 2009 and 2012. That is a massive 27-year delay. They argued the case should just be thrown out immediately, basically saying, hey, you can't suddenly strip away citizenship rights that have been established for almost 3 decades.
Well, the crucial point here is that the court actually disagreed on this technicality. They ruled that when issues involve massive public policy concerns, like the security of the state, the cultural rights of indigenous communities, and potential systemic discrimination, an artificial deadline simply cannot block a constitutional review. The issues were literally just too big to ignore just because some time had passed.
Which brings us to Section 3, the constitutional issues.
Having cleared that procedural hurdle, the petitioners didn't hold back. They launched a multi-pronged challenge, arguing Section 6A violated several fundamental pillars of the Constitution. First up, Article 14, the right to equality. They asked, why is Assam the only state subjected to this specific cutoff date, while the rest of India has different rules? Second, Article 21. Does this massive demographic shift impact the right to life and sustainable development? Third, Article 29. Does this influx erode the unique culture of the Assamese people? And finally, does this immense scale of undocumented immigration actually amount to external aggression under Article 355, which would obligate the union government to step in and protect the state?
So after all those complex arguments, it really all boiled down to this one defining question framed by the Constitution bench. Does this 1985 law actually suffer from any constitutional infirmity? Does it break the rules?
Section 4, the majority ruling.
Let's look at what they decided. The majority, which included Chief Justice Chandrachud and Justice Surya Kant, firmly upheld the law. They declared that Section 6A does not suffer from constitutional infirmity, finding it to be a completely valid piece of legislation crafted to resolve a highly specific historical crisis.
Now, you might be wondering, how did they justify treating Assam differently to satisfy the equality claim? Well, the court ruled that Assam faced a uniquely massive scale of undocumented immigration compared to other border states. Because the problem was exponentially larger and way more disruptive there, it formed a distinct homogeneous class. Therefore, Parliament was well within its rights under Article 14 to create a specialized legal framework just for that region. It wasn't arbitrary discrimination, right? It was a targeted solution to a targeted problem.
Furthermore, the majority rejected the claims about the destruction of Assamese culture and the right to life. The court noted that the petitioners simply failed to provide concrete, actionable material proving that Section 6A itself was the direct cause of cultural erosion under Article 29 or that it violated Article 21. Basically, they said that while demographic shifts absolutely happen, just granting citizenship via these historical cutoff dates didn't automatically equate to a constitutional violation of cultural rights.
And finally, Section 5, the dissenting opinion.
But, in the Supreme Court, a powerful dissent can really reshape how we understand the law. Justice J.B. Pardiwala authored a lone but highly detailed dissenting opinion, and he viewed the matter from a completely different dimension. While he agreed with the majority on many of the preliminary issues, his final conclusion on the constitutionality of the law took a stark, fascinating turn.
He introduced this absolutely fascinating concept called temporal unreasonableness. Think about it. Can a law become unconstitutional just because time passes? Justice Pardiwala argued that Section 6A might have been a perfectly valid, well-intentioned political compromise back in 1985. But, and this is a big but, the mechanisms built into the law to actually detect and deport the post-1971 illegal immigrants completely failed over the subsequent decades. Because the law failed to achieve its core objective over time, he argued it had become arbitrary, and therefore unconstitutional by the mere passage of time.
But here's the catch. This created a massive dilemma. If you strike down a 40-year-old law as unconstitutional today, what happens to the millions of people who already legally acquired citizenship under it since 1985? To avoid absolute chaos, Justice Pardiwala utilized the doctrine of prospective overruling. This basically means he declared the law invalid, but strictly for the future. Anyone who had already secured citizenship would be protected, but moving forward from the date of the judgment, Section 6A could no longer be used.
So we are left with a really sharp legal split here. On one side, we have a majority emphasizing constitutional flexibility, ruling that Parliament can create unique laws for unique state-level crises without violating equality. On the flip side, we have a dissent fiercely focused on the practical reality of the law's implementation, arguing that a prolonged administrative failure eventually renders a law unconstitutional.
There's a powerful quote in the judgment that perfectly underscores this dynamic power of the Supreme Court. It shows the court isn't just a rigid interpreter of old texts. It has the incredible discretion to mold its relief to meet the ends of justice, ensuring that fixing a legal error doesn't accidentally trigger a massive humanitarian or administrative disaster.
Understanding this whole explainer is absolutely vital, because while the majority ruling settles the immediate legality of Section 6A, the entire debate leaves us with a profound question about the future. How should our legal frameworks adapt to balancing the deep-rooted cultural rights of indigenous populations against the complex, often unstoppable practical realities of historical migration? It's a serious tension, and it's one that isn't going away anytime soon. Thanks for joining me on this deep dive.